My Lady, my Lords, in this matter I appear for the appellants, along with Ms Seymour. Mr Eady, Mr Piewski appear for the respondents, the Commissioners for Revenue and Customs.
I think I've got somebody else's papers here.
Look like mine.
Yes. I seem to have two sets, and I didn't think I needed two. There we go. Now, begin again, please, Mr Tomlinson.
My Lady, there is an agreed timetable, and I think the Court is aware of it. I have 2 hours, and then the afternoon is divided up, as you will have seen. This is an appeal concerning the lawfulness of the disclosure of information concerning identified people by HMRC. The facts may be, as the respondents say, particular and unusual, but the case engages what we say is a fundamental question. In what circumstances is it permissible for the revenue to disclose its views about identified taxpayers to third parties? In this case, the revenue, in the person of the Secretary for Tax, the then Secretary for Tax, Mr Hartnett, chose to discuss the appellants at an off-the-record press briefing. As a result, the revenue's views of the appellant's affairs ended up on the front page of the Times. We say that the decision to name them at the briefing and to discuss their affairs was unlawful. This position taken in that briefing and in this court stands in stark contrast to the strict and we say correct refusal of the revenue to discuss the affairs of individual taxpayers before the Public Accounts Committee or indeed in other public fora. It's not entirely clear why Mr Hartnett made the decision to discuss the appellants as he did, but on the basis of his evidence, we say his decision to disclose as unlawful. It wasn't necessary for the discharge of any function of the revenue for him to give the name of the appellants, let alone to give his views to journalists. The non-disclosure obligations of the revenue are strict, and that's for good and well-recognised policy reasons. The revenue's case in this court amounts to the contention, we say a novel contention, that the revenue can disclose the names of taxpayers and their views about them whenever they think that this might produce some unspecified general benefit for tax collection. I'm going to make submissions, time available, under 5 headings. First of all, I'm going to deal with some brief points about the facts. Secondly, I'm going to deal with the first issue, which concerns the effect of Section 18(2)A of the Commissioners for Revenue and Customs Act. I'll submit that the power to disclose information relating to an identified or identifiable person for the purposes of collecting tax is a limited one. And in any event, the exercise of the discretion to disclose was unlawful in this case. Thirdly, I'll submit that the revenue were in breach of a...
We'll need to develop whether discretion comes into it.
Yes.
The courts below proceeded on the basis it was discretionary. Most clearly,
yes.
in Justice Sale's judgment, there is a question mark whether in the area of duties of confidence you are in the territory of discretion, properly so understood.
Yes. Well, the case is that although there is an element of confidentiality in this, as I'll come to in a moment, the non-disclosure obligation in Section 18 isn't, although it's headed confidentiality in the statute, isn't actually about confidentiality at all. It's a general prohibition on disclosure. And the essence of the complaint is what's disclosed is the revenue's views, their negative views of these applicants.
Well, that again, I think, is something we're going to have to look at rather carefully. Is it as you say, not about confidentiality at all, or is it in truth all about confidentiality?
My Lord,
Or is it a statutory duty that is premised on a common law obligation
Yeah.
of confidentiality?
Because it may be that the starting point that it prohibited that the section, subject to very widely drawn exceptions, prohibits anything being disclosed by way of information, whether it has the badge of confidentiality and whether the whole world knows about it, is wide of the mark. And that's not actually what the section was aimed at. But this will be a matter we'll have to look at.
yes, and just so that the court can be clear, we say that, and indeed this is reflected in the commissioners, in the guidance, we say that it's the effect of sections 18 and following are exactly as my Lord Tilson puts it, a very absolutely general prohibition on disclosure of any information at all, public domain being irrelevant, but then there are a series of tightly drawn exceptions which are designed to reflect the position where disclosure is necessary for the proper operation of the revenue.
Well, if it applies to any information at all, it would apply to not publishing the name of the office or who works for the revenue. And all that's information relating to the revenue. I mean, as a public body, it has to do a lot of its operations publicly.
Yes.
Query whether Parliament actually intended to ban publishing anything about what it does in any realm at all, subject to very widely drawn exceptions. But we'll explore that.
Well, we'll explore that, if I may, a little later.
In connection with a function wouldn't be as wide as to cover the offices of the revenue. I mean, that's in connection with a function, look shortly to something which they do in their offices or in their business.
Well,
You start off with something which is a bit more circumscribed than I think Lord Tilson was suggesting.
We need to see what it is that the courts below held and the respondent argues for by way of definition of function when you take the three relevant sections together.
yes.
The initial one, the ancillary powers section, and the interpretation section at the end.
Yes, and also we say that section 19 is of crucial importance, as I'll come on to. So that was the second and perhaps crucial area. It concerns section 18.
Let's get back to number 3.
And its operation. That 3 concerns legitimate expectation and abuse of power. Fourth concerns the claim under Article 8 of the Convention. And finally, I'll say something briefly about the claim under Article 1 of the First Protocol, but I make it clear that that's parasitic on the others. The first 3 points, the points concerning Section 18, legitimate expectation, and Article 8, are different ways of putting the case that I'm trying to make, that the disclosures were unlawful. If the disclosures were lawful, then Article 1 of the First Protocol is not relevant. If they're unlawful, then I say that there's a claim under that as well. The facts, I'll say something about briefly now. They're found at paragraphs 3 to 10 of the Statements of Facts and Issues and are relatively, largely uncontroversial. On the 14th of June 2012, Mr. Hartnett, the then Secretary for Tax, conducted a 75-minute off-the-record press briefing with 2 Times journalists. In the course of that briefing, he discussed the second appellant by name, Mr. McKenna, and the business of the first appellant, Ingenious. What he said was, we say, in pejorative terms. On 21st of June 2012, so a week later, much of what Mr. Hartnett said appeared in the Times on the front page and on a large spread inside the newspaper. Those articles, I don't think it's necessary to turn them up, but are Appendix 2, C1, page 242 and following. Can I just make 4 initial points about the facts? The first is that it's important for the court to be clear about the appellants and the so-called film schemes that are being referred to in the briefing. The appellants are specialists in investing in the media and creative industries and are one of the largest investors in such industries in the country. The second appellant is a very well-known figure in the business. Some details of his background and the company's background are set out at paragraph 3 of the Statements of Facts and Grounds. That's Appendix 1B53. Again, I'm not going to take the court to them in the light of the time available.
But when you do refer to something, can you also give the electronic bundle?
They're the same.
Quite right too. But it's still helpful to get the number.
Those references are the same. So
3, I think you said.
I'm so sorry. You're quite right. I've missed something out of
You
my
have?
out
Yes.
of my note, and that's entirely my fault. It's A1, B5, and it's at
53.
Page 177.
177.
That's what I dropped
And the
out.
actual articles that appeared in
The
the
articles are
Times?
at 242 to 250.
Thank you. Do please try and remember to do that.
I'm so sorry, and I will try. During the briefing, Mr. Hartnett spoke about involvement of the appellants in film schemes. That's the use of the word schemes suggests some kind of artificial scheme for generating tax losses, relying on special tax reliefs. That's not the nature of the appellant's business. They produce films. There's references in the papers to the well-known films such as Avatar, Mr. Turner, Life of Pi, which they've produced. These film partnerships were originally sale and leaseback partnerships under a controversial but now repealed statutory regime, which was, the court may remember, designed, I think, by Mr. Gordon Brown to facilitate investment in the British film industry. Those partnerships are not connected to this case. They were never objected to by the revenue. Between 2002 and 2009, the first appellant marketed film production partnerships. These were trading partnerships designed not to take advantage of any specific tax reliefs for films, but simply to take advantage of the tax reliefs available to any partnership investing in a business. The appellants have been in discussion with the revenue about these partnerships and their tax treatment throughout the history. From the beginning, they went to the revenue to discuss the nature of the partnerships and whether or not the revenue were satisfied that they were properly commercial, which is the relevant test. The details of that history are set out in the Statements of Facts and Grounds, paragraphs 55 to 73, that's 198 to 203 of the bundle. I'm not going to take the court through it, but it's important to emphasise these points. The appellants have at all times been transparent. This isn't controversial, as I understand it. They've disclosed the details of the partnerships to the revenue. They've entered into discussion with them, and they've received their at least conditional approval for the way that they're structured. The partnerships would never have been established if the revenue had indicated there was something wrong with them. Secondly, and this is, we say, a very important point, in June 2012, when Mr. Hartnett met the journalists, the revenue had not reached any decision as to whether the film partnerships in question were trading commercially. They had not issued what are called closure notices, and no legal proceedings had been commenced. The first closure notices didn't come until the 30th of November 2012. That's 5 months after the briefing. There's an error in my case on this point. We refer to notices being issued in early 2012, but in fact, it was common ground below, and Mr. Justice Sales recorded at paragraph 11 of his judgment that the closure notices were not issued until November of the same year. In other words, at the time that Mr. Hartnett was briefing the journalists, the Revenue had not even decided whether the Ingenious Film Partnerships were entitled to the appropriate tax reliefs or not. The views of the Revenue were given to journalists before they were officially given to the appellants. That's my first point. The second point concerns the terms on which the meeting was held. This is important because the courts below and the Revenue in this court place some emphasis on the fact that Mr. Hartnett said that the meeting was off the record. The Revenue say that there was some kind of confidentiality agreement and that disclosure was intended to be restricted and that this somehow makes the disclosure lawful. But there was no agreement of confidentiality.
Would it make a difference if there were?
Well, if the position is, as your Lordship knows, if one of the elements of misuse of confidential information is a misuse, and there may not be a misuse if you give it to a person who themselves has agreed to keep it confidential on the same terms in which you hold it.
Gracious me. So, the fact that it's secret doesn't stop you telling somebody as long as they promise not to tell somebody else.
It depends. My Lord, it depends. But in the context, we would say, of conventional law of confidentiality, the terms on which you disclose it are a relevant factor. It's very common for confidential information, obviously, to be disclosed in all kinds of circumstances.
Yeah, for a proper purpose.
For a proper purpose, to
Precisely.
other people who hold it, and one of the questions as to whether the purpose is proper is whether the people to whom you've disclosed it agree that they hold it on terms of confidentiality.
If the press are being informed about matters as watchdogs for the public, their business being to pass information on to the public, question would present itself, is it legitimate to give information to a member of the press if it wouldn't be legitimate to give that same information to, for instance, a parliamentary committee or the public at large?
Yes. Well,
Anyway, it's just a thought.
yes. You see, the position here is that the courts below and the Revenue take the view, as we understand it, that while it might have been objectionable for the Revenue to issue a public statement saying Mr. McKenna is running scams for scumbags, to make the same statement to journalists subject to confidentiality obligations is less damaging.
What do you say?
That's a different point. Less damaging. I mean, that goes to damages.
Yes, but my Lord, it does. But the point whether it goes to damages is a question. But the point I'm making here is just to be clear as to what the terms were that on which the disclosure was given. And Mr. Eady says in his case at paragraph 7, that's at page 108, that there was a confidentiality agreement, and that's not right. What the position was that it was agreed that the briefing would be off the record. Now, that was understood by the Revenue to mean that nothing would be published. They're wrong about that. That's not the way that journalists understand off the record, but that, in a sense, doesn't matter.
I thought there was evidence in the transcript that was how they understood this, because when he emphasised that the reference to scams for scumbags, well, when that was made, but he emphasised that was off the record, the journalists said, oh, it's a pity we won't be able to publish it. So I thought there was a degree of common understanding.
No, because that's not for attribution. But my Lord, it doesn't. It doesn't matter. Forgive me. It doesn't matter in this sense that what the Revenue did not do was sit down in advance and say to the journalists, we are going to disclose only on these terms. They did not enter into any clear confidentiality understanding. They had an unclear view as to this was off the record. Now, one can debate about what that means and whether it...
Well, Mr. Tomlinson, you're a leading media lawyer. Presumably you know what you think off the record means. Have we got any expert evidence on it?
We don't. We don't, and I am not going to give it. That would not be appropriate. But
I suppose what you can say is that of its nature, a term off the record, potentially at least, covers a very wide spectrum.
it potentially covers a very wide spectrum. But what we know...
And you say that precision was required here.
Yes, exactly. And the point I'm making is really a very simple one. If the Revenue wanted disclosures to be confidential and to be not disclosed by journalists to the public, which is what you'd expect normally, because as my Lord Tilson says, you're giving information to the journalists as watchdogs for the public. You expect them to disclose it to the public. If you don't want them to do that, you've got to be crystal clear about what the position is. And they weren't crystal clear.
I find this a little elusive. I mean, off the record clearly means something, and it clearly means that it mustn't be treated as having been said, doesn't it? It's not being... it's as if you were making a recording of the interview, but that bit is not on it.
Well, my Lord, no. That's...
What you say that if you say to someone that this is off the record, they can then go and broadcast.
Without attributing it to you. Yeah.
Well, that is Chatham House rules, or rule. That is not off the record. So, anyway, perhaps I'm wrong.
But the position, the simple point I'm trying to make is this: that the Revenue were not clear about the terms that they were disclosing this information.
But cutting through this, I think you would accept, I imagine, that there can be circumstances in which disclosure of information for restricted use might be legitimate, where disclosure of the same information for unrestricted use would not be. Yes. Examples are obvious and every day.
Yes, absolutely.
The question you're really addressing here is, was it legitimate to be disclosing this information, whether on a restricted or a non-restricted basis?
Yes.
Yeah.
It is, but I'm going to have to meet at some stage the point that because it's disclosed on limited terms, that's less serious than that's a lawful exercise of the discretion, which it might not have been if it was disclosed for publication on the front page of the Times. That's the argument against me.
But I mean, I thought that the simple point is that if a duty of confidentiality is owed to the taxpayer, it's a breach of that duty to disclose the information to a third party, even if the third party promises he's not going to pass it on.
Yes. Yeah. Yes, that's certainly right. But you will have seen from the judgments below that both Mr. Justice Sales and the Court of Appeal laid considerable weight on the fact that the information was being disclosed, so Mr. Hartnett thought, on terms that wouldn't go any further.
Well, Mr. Justice Sales's whole approach is that there's effectively a statutory power of disclosure subject to Wednesbury limits.
Yes.
And so you ask yourself, have those limits been breached?
Yes.
And I think Lord Toulson's first question this morning was questioning whether that's the correct way of looking at this.
Yes. Well, we say it's not. But, my lady, can I move on to my third point? Time is running on. The third question is, what was the purpose of this briefing? And what, in particular, what was the purpose of talking about the appellants? The Revenue's case is that there were three purposes. This is set out in their detailed grounds at page 217. First of all, so that the journalists and, it was to be hoped, their words, the wider public would properly understand the revenue's threats and challenges on tax avoidance. I say, in parenthesis, a perfectly proper and laudable purpose, which doesn't require any disclosure of any information about the appellants. Secondly, so that what they wrote would be less likely to promote the incorrect impression that HMRC did not effectively challenge tax avoidance and discourage elaborate tax avoidance schemes. In other words, to make it clear that they were serious in combating film schemes. And thirdly, so that the journalists might provide information about the appellants or others, so that the journalists might give them information in return.
Do you accept that if there are only two people in the market, in the film scheme market, and if the revenue wishes to discourage any public impression that this is a safe form of investment or the tax-effective form of investment, it wishes to, it is entitled to issue some statement to that effect, even though the inevitable result will be to point the finger at the two people who the whole world knows are the only two people involved in that market. Do you accept that that's...
Well, if there, I don't think there's ever been any evidence that there were only two people. Indeed, I think it's not the case. But of course, one can see your Lordship's question. If there are limited numbers in promoting...
The finger will inevitably be pointed at them.
But fingers will inevitably point at them.
As soon as the revenue says to the public, look, these schemes are not safe, we've got them in our sights, and don't invest in them, they may be tax ineffective.
Well, there are two points about that. First of all, these schemes are not, contrary to the position, the view taken by the Court of Appeal, these schemes were not being promoted at the time. They were closed. They were history. So there was nothing to discourage in the future.
Yeah.
By reason of statutory changes in 2007 and 2009, the tax advantages from film investment partnerships had ceased. So this was a historic problem, not an actual problem. One sees that partly from the transcript. But secondly, I don't accept that the revenue can condemn particular arrangements in advance to journalists before they've actually made a decision whether or not these schemes are improper tax avoidance. Of course, if they've made the decision, and if they've informed the taxpayers that these schemes are schemes which are not going to get tax advantages, and for example, if there are tribunal proceedings on hand, they can perfectly properly warn the public of that similar schemes are going to lead to difficulties. But none of those conditions were fulfilled here.
Because that's only 5 months later, you were saying?
That's only 5 months later.
Yeah.
And perhaps I could just make this point in passing. Attached to the grounds of resistance below, that there were what's said. This is at page 225. There are references to a number of previous press articles which state that the claimants are being investigated, the appellants are being investigated by the revenue. So it was in the public domain that the revenue were interested in them. But that is something completely different from saying that the revenue have decided that these are illegitimate tax avoidance schemes. The revenue investigate a lot of people and decide to take no further action. It also, I'm dealing with the purpose of these, of the briefing, and I've dealt with the way that they put it in the detailed grounds of resistance. It also appears, and this is stated in my friend's case, that they wanted to counter media speculation about the revenue's willingness to enter into cosy deals with certain taxpayers. That's paragraph 6, page 107. That's not a purpose which is mentioned in the evidence, but it's interesting that that's, again, not a purpose which requires any specific mention of the appellants. One can quite see Mr. Hartnett might want to say to journalists, look, we don't do cosy deals with taxpayers, that's completely off the radar. But there's no reason for him then to go on to set out his views of the appellants. The fourth point, I just want to take the court briefly to the transcript, which is to be found beginning at 349. This is the briefing itself. There's a summary of...
what page was it?
349. It's it's 349 electronic, and it's Appendix 2, Tab 8. Appendix 2, C8, 349. It's a lengthy document, and I'm not going to go through it in any detail, but it's summarised in the judgments of the courts below. But it begins with a discussion, perfectly proper discussion of tax avoidance and DOTAS and various other matters. And then at page 358, responding to a question from one of the journalists about how long the cases were taking, Mr. Hartnett says, this is 358, about a quarter of the way down, it's complete bollocks, we can't control the tribunal, and then he goes on to mention a particular individual whose name has been redacted from this transcript. That's not Mr. McKenna, it's another individual involved in film schemes. So the name of an individual is introduced by Mr. Hartnett into the discussion. Then, over the page in 360, Mr. Hartnett goes on to say, the top of the page, he's talking about engaging with individuals who promote tax avoidance. And then there's another individual in the field who you haven't mentioned. I've seen him too. So he's then mentioning another, and the journalist asks the question, and then Mr. Hartnett confirms him as the person being referred to. And then the journalists say, well, do you see him in the same light as the others? And then Mr. Hartnett says, yes. And then at the bottom of that page, you find, first of all, Mr. Hartnett says film schemes are a 5 billion risk for us at least. And then someone says...
Yes, it's off the record.
Yes.
Four entries from the bottom of the page.
Yes.
Yeah.
Which has been closed currently, and then he talks about old film schemes, and that's the point that we're talking here about schemes which are historic. And then there's some further discussion about film schemes. And then if I could go to 363 at the bottom, Mr. Mostrous, the journalist, says, with McKenna, do you think he's enacting any active schemes or schemes that we use to deprive the revenue of tax now? Again, recognition that the question is there anything current? To which Mr. Hartnett says, I don't know. So Mr. Hartnett can't be said to be discouraging investment in current tax avoidance schemes, doesn't even know whether there are any. Then Mr. Mostra says he's not on your radar in any sense, and then he's never left my radar. And then what do you think of him? Because he presents a very, very different profile. That's from the other individual already named. And then there's the passage where he goes into some detail. He's an urbane man, former Deloitte's partner, banker, big risk for us, a lot of tax relief he's generated for himself and other people. Are we winning? And then he goes on to make the remark, Mr. Mostras asked whether it applies to McKenna as well as film schemes in general. And then Mr. Hartnett says we're going to clean up on film schemes. I'm not sure we've got anyone who thinks film schemes are anything other than scams for scumbags. So, with the exception of scams for scumbags, all that appeared in the Times article the following week, attributed to a senior official of the Revenue. So Mr. Hartnett gives the journalist the benefit of his views about Mr. McKenna. He again, page 365, just in passing, 2/3 of the way down, at the end of the long quote from Dave, I think the UK has now tamed the abuse of film schemes. They've got a lot of clearing up to do for the past. So again, we're talking about historic matters. The discussion moves on from film schemes, but there's one other matter which is important to note. Page 369, Mr. Mostras of the Times raises the issue about the confidentiality, tax confidentiality, and the page 370, the bottom. Why can't you name them? That's a government issue, not our issue. And Mr. Mostras suggests it would have a deterrent effect. And in that part of the interview, Mr. Hartnett goes on to repeat the Revenue's historic and very well-known position that it's not appropriate to name individual taxpayers, even though they're promoting tax avoidance schemes. Now, the things that were said in the course of that interview, we say there can be no doubt that those constitute disclosure for the purposes of Section 18. The Revenue's case is that there was no information provided to the appellants which was passed on. That's paragraph 10 of their case at page 110. All they did, say the Revenue, was give Mr. Hartnett's views of the appellants, and the judge regarded that as being a less compelling case for maintaining privacy. But we say that seriously underplays the nature of those disclosures, because what was happening was that the Secretary for Tax was telling the Times the Revenue's views of Mr. McKenna and his companies, and that they were promoting scams and billions of pounds are at stake.
They also gave him factual information that Mr. McKenna had generated lots of tax relief for himself.
For himself, yes, he did. And that's a point that we stressed below, and which the Court of Appeal didn't seem to regard as being of great significance. So against that factual background, let me turn immediately to the first issue, which concerns the operation of Section 18. I hope that the Court has a small bundle of relevant legislation. Very good.
What's very unfortunate, or might be unfortunate, is that nobody, I think, has addressed any of the courts below or put in our bundle the leading authorities on the common law in this area in the context of which the Act was passed. And the principle referred to in later cases, the Marcel principle, which goes back to Marcel and the Commission of Police in 1992, I think, and was thereafter referred to in a number of House of Lords decisions, Privy Council, and one Privy Council decision in tax contexts, has just not received any thought at all. It does seem to me that this Act was not passed in circumstances where the canvas was entirely blank. The principles of confidentiality in this area are extremely well established, and in general terms. And one therefore possibly has to have regard to the Sims principle of legality, and consider whether Section 18 was intended substantially to reduce taxpayer confidentiality rights as existed in common law. Now, that's a topic which simply hasn't so far been addressed in this litigation.
Well, in a sense, it's for Mr. Eady to address it rather than Mr. Tomlinson then to reply to it.
But Lord, we've come at this, and we may be wrong about this, we've come at this from a slightly different perspective, because as we've set out in our case, if I just go to the passage, what we've said something about the of course there's a whole body of case law on the question of the use of information by public authorities, the sort of case law that your Lordship is referring to. But the question of taxpayer confidentiality has a distinct history.
Yes.
Which, as we say, goes back to Pitt the Younger's speech in the House of Commons when the very first Income Taxes Act was Income Taxes Act was introduced. This is page 53. Sorry, paragraph 53, page 77 onwards, and the way it was dealt with. Historically, originally, officials of the revenue were required to swear an oath, and that became a statutory declaration, which then was, and we set out the terms of the statutory declaration at paragraph 54, and the concurrently to the system of oaths and declarations, there was the strict restrictions on disclosure of official information, beginning with the Official Secrets Act of 1889. And again, we've set that history out, and
you do, in fairness, refer to the National Federation of Self-Employed and Small Business case. 76, paragraph 6, and you cite what Lord Wilberforce had to say in that case. You don't cite what Lord Scarman also had to say, page 654, but that's another matter.
Yes, but the view we've taken is that the history of taxpayer confidentiality has as it were, developed on its own separate track. It's related to the general law of confidentiality, but it's operated in a different way. Now, Section 18 is certainly not intended to change the pre-existing law. I'll make that point good in a moment.
Well, there's a difference between perhaps the statements in Prime Minister Pitt's statement and the earlier tax legislation and the Official Secrets Act, all of which refer to information communicated to or received by or acquired by the official, whereas the present section is information which is held by, so which may be slightly wider.
Yes. Well, the position is that Section 18 is the starting point, and that's in the legislation bundle, which is it's at 1250. Yes. Yes, Ms. Seymour reminds me we relied on Lord Scarman, for Lord Toulson's note, we relied on Lord Scarman in the Statement of Facts and Grounds on paragraph 79, page 208, where he uses the interesting phrase, the total confidentiality of assessments, which suggests something slightly similar to Lord Wilberforce's words, a slightly stronger test than, as it were, or ordinary confidentiality. But can I 1250, which is section 18? begins with a prohibition. The Revenue and Customs officials may not disclose information which is held by the Revenue and Customs in connection with the function of the Revenue and Customs. And then there are a number of exceptions, of which the relevant one here is 18(2)(a)(1), made for the purpose of a function of Revenue and Customs. And the argument against us, as we understand it, is simply, well, Mr. Hartnett was making these disclosures for the purposes of collecting tax. He believed they were for the purposes of, they would help the revenue in collecting tax. Therefore, that's for the purposes of a function. Therefore, he was entitled to make them. We say that that is inconsistent with the statutory scheme. That it is, as my Lord Toulson says, perhaps just necessary to look at the statutory, the interpretation.
Well, there are three sections, aren't there? There's Section 6, Section 9, and Section, whatever it is at the end.
Yeah, 51(2). 51(2). Function means any power or duty, including a power or duty ancillary to a power or duty. Section 6 sets out the initial functions of officers of Revenue and Customs.
Sorry, Section 5.
Section 5 it deals with the collection and management of revenue.
My error, I referred to 6, I meant 5. Section 5 lays down the fundamental purpose for having commissioners. They're responsible for the collection and management of revenue, both what was inland revenue business and what was customs and excise business. They've been amalgamated. And then such other functions as were vested in those respective commissioners. That's the core purpose for which they hold office. Then Section 9 confers on them ancillary powers, anything which they think necessary or expedient, or anything which they think incidental or conducive. I mean, you could hardly have wider words than those.
Yes.
And then you come to the interpretation at 51(2).
Although that's wider than Section 18, because Section 18 refers to functions as opposed to ancillary powers.
Yes, but when you come to 51(2), function includes anything which they have a power to do. Including ancillary.
Well, I accept it's in wide terms.
The question really then becomes whether, when you read together 5, 9, and 51(2), they and then apply them to 18, they effectively enlarge what can be disclosed so broadly that it entirely depends on the view of somebody in the revenue, whether this is, in his opinion, incidental or any of those other words.
Well, and that essentially is Mr. Eadie's argument in this
Right.
report. And we say that although if one concentrates only on those sections and looks at nothing else, that might be the position one arrives at. It's vitally important to turn over the page and look at Section 19. Sorry, just before I do that, Section 18, although it's headed confidentiality, actually, when you look at its terms, it's much wider than confidential information.
No, but the heading may point to what it is really aimed at, that this is a section essentially aimed at protection of taxpayer confidentiality.
Well, Your Lordship says that, but if going then to Section 19, this is the criminal offence, and this is the criminal offence which arises where there's a disclosure of information relating to a person whose identity is specified in the disclosure or can be deduced from it. So it's identified or identifiable persons. Now in this section, there are a number of defences. The 3A is the disclosure was lawful, in other words, in accordance with Section 18, or indeed the later sections about public interest disclosures. And 3B, the information had already and lawfully been made available to the public. So 3B would be unnecessary if the fact that there's as it were, a public domain defence shows that the section is intended to go wider than purely confidential information. That would be unnecessary otherwise. Now, Section 19 clearly puts information relating to an identified or identifiable person in a separate category from any other category. It's unusual, to say the least, to have a criminal offence relating to disclosure of information. And we say that that's consistent with the whole history and tenor of the revenue non-disclosure or confidentiality obligation. That of crucial importance is that the revenue don't disclose information relating to identified individuals. There are a series of, and we say that the wide words, and as Lord Tilson rightly says, taking the sections together, you may get very wide words indeed in Section 18.2a, that those wide words have to be cut down by looking at the context in which the statute was enacted and the way that Section 19 operates. In terms of the context, I've already mentioned the history of oaths and declarations.
So did Section 18 spring fresh onto the statute book? It seems to me to be extraordinary that there weren't some previous provisions to similar effect in either the law, the provisions relating to the Inland Revenue Commissioners or to the Commissioners of Customs and Excise.
Well, there was the Official Secrets Act, and then there was.
But that had already been considerably cut down, hadn't
yes,
it?
that
by
was cut down in
2005.
that was cut down in 89. But the position was then that there was then if you turn to 79 in our case, page 79, paragraph 57. Section 182 of the Finance Act 1989 was in effect enacted to fill the gap produced by the repeal of the Official Secrets Act of 1911.
Just to pursue Lady Hale's point a moment, do we get help from paragraph 93 of the explanatory notes?
Well, I just about to, that was open in front of me, and I was just about to go to it. 1262. And the paragraph 93 of the explanatory note to Section 18 makes it clear that the section's based on the provisions of the statutory declaration and extended it as a statutory duty to commissioners of the new department. So the old scheme was oath or declaration allied to Official Secrets Act and then Finance Act 1989.
So it's perceived by the drafter to have been a code of confidentiality based upon prior legislation, and subsection 2 is perceived by him as providing for a limited number of specific circumstances.
Yes, exactly so. And certainly not a general discretion to disclose anything you think would be useful.
Can I just mention You've produced for us an article about taxpayer confidentiality from the British Tax Review,
Yes.
which is in tab 21.
Yes.
And at MS 1227, the author of the article states that taxpayers enjoy the same protection from the general law on confidentiality available to other individuals and companies, and then cites as authority a Privy Council judgment, quite a recent one, called Mount Murray Country Club, which isn't in our authority.
No.
That may be the one that Lord Tilson...
Well, it's one of them, because paragraph 33, I think, that
Yes.
judgment.
But as...
Effectively, the implication of that is that while we have in statute a provision which can be traced back to the Official Secrets Act, which forbids disclosure of information in general held by Revenue and Customs, there is the narrower category of confidential information in which there is a right of confidentiality in the taxpayer, is protected by the common law of confidentiality.
Yes, well, I don't think there can be any doubt about that second proposition. But in this case, I mean, we say that the obligation of the revenue goes wider because it's not just what is traditionally perceived as confidential information, the contents of my tax return, or something which are plainly confidential information, and the revenue owes me a duty of confidence both at common law and under all the provisions that govern its information disclosure. Here, the argument that's run against us is, well, there's really very little confidential information disclosed by Mr. Hartnett. That really all he's saying is absolutely obvious to anyone, namely Mr. McKenna's got a lot of tax relief, but then he's giving the revenue's private views of Mr. McKenna and Ingenious. The revenue's private views wouldn't normally, in as it were, the classic law of confidentiality, be treated as confidential information, and it's because of that we base our case on a broader approach. I mean, Section 18...
But you don't have to base your entire case on a broader approach. You can say, I mean, I understand that insofar as what's being conveyed isn't confidential information, but that other information about the revenue's views of a taxpayer, then you may have to appeal to some principle of abuse of power or something of that kind. But insofar as they are conveying confidential information about a taxpayer's affairs, I'd have thought you don't have to peril your case on some broader,
No, I don't.
public law principle.
Your Lordship's right, and insofar as it's confidential information, which is I have to accept it's a limited class of the information in this case, then I can rest myself on the common law. But I do have to take the broader point as well. Now, I took you to, with Lord Tilson's help, to the explanatory notes. Can I just also take you very briefly to the parliamentary debates when this section was being enacted?
Is that legitimate?
Well, if there's some uncertainty about what the Section 18 is intended to achieve, as there clearly is, we would say, then statements by the promoter of the bill, who is the Attorney General, on this very point are we say, helpful to the court.
Well, you would say there isn't any uncertainty, but of course your opposition says that there is.
Exactly so. Can I take you to 1187, which is an extract from Hansard.
What was the page again?
1187.
Something.
It 1187 is a probing amendment by Lord Kingsland to Section 18 2A, and his amendment is that section 18.2a be removed from the Act. And his concern is that it's too wide. If one takes it up about three-quarters of the way down, the amendment, its purpose is to probe. I wish to test the boundaries of the provision. We all agreed the mandatory duty of statutory duty of confidentiality and taxation information is entirely welcome. It seems that the drafting of paragraph A could have the effect of undermining this important principle. As I read it, the paragraph delivers a broad widening of the scope to disclosure, no restriction on the persons or bodies to whom information could be given, on the character and scope of the information disclosed, only further onward disclosure. He's complaining that this has the effect that Mr. Eadie says it has. And then the noble and learned Lord, I'm sure, this is the bottom, will discern a major cause of my concern, have the effect of relieving HMRC of any requirement to obtain further statutory gateways, permitting disclosure in specified circumstances, severely limit the capacity of Parliament to scrutinise properly extension of disclosure powers. Lord Goldsmith, who was then the Attorney General, the sponsoring minister, I hope I can meet the Noble Lord's request. Clause 18 provides legislation for predecessor departments did prescribe circumstances where disclosure is permitted. Disclosure allowed for by 18.2a could range from advice to ministers on policy matters to day-to-day operational activities. This ability already exists. Noble Lord concerned to explore the breadth of the power, important to note the purpose which disclosure may be made is constrained by being for the purpose of a function, and refers to restrictions. Function means the functions given to HMRC by Parliament, collection and management of revenue, and those ancillary to it. Doesn't do away with the need for statutory gateway. So he's reassuring Lord Kingsland that it's not a broader provision. And then three-quarters of the way down, Lord Kingsland goes back to him, asks whether it's widening the scope of disclosure available to the HMRC. Am I right in interpreting the noble and learned Lord's reply? I'm simply wrong about that and ought not to be concerned. Is he in effect saying the bill simply endorses the status quo with respect to the scope of confidentiality and number of people involved? If so, that will be the end of the matter. And Lord Goldsmith answers, yes, it does, apart from referring to the prosecuting authority. So it's plain from both that and the explanatory note that the purpose of Section 18 was not to extend the scope of disclosure available to the revenue and customs. It was to effectively put into statutory form the law that it had previously been understood to be. The next point I rely on, and we say this is of some importance, are the subsequent statutes which have dealt with disclosure of taxpayer information. These are statutes where Parliament has specifically legislated to permit disclosure of information concerning individual taxpayers.
And how do later statutes help us interpret Section 18?
Can I refer to the case of ZYN and Walsall Metropolitan Borough Council? It's at page 1000, E12, Second Authorities Bundle. That in certain circumstances, later statutes can. The case starts at page 988. And one of the issues in that case was to what extent subsequent legislation could be used to cast light on previous legislation. That begins at paragraph, the discussion of that begins at paragraph 52. And I don't propose to read these paragraphs unless the court would wish me to, but the point put simply is if Parliament legislates on the basis that an earlier statute has a particular meaning, then that's an aid to construction of the earlier statute.
So which are the particular paragraphs again?
I'm so sorry, my lord, it's 52 onwards. It's page 1,000 to 1,002. And a number of well-known cases are cited where the courts have taken into account subsequent statutes to cast light on the meaning of previous statutes. Now, in this case, it is, we say, particularly striking because in two subsequent statutes, the Finance Act 2009 and the Finance Act 2012, Parliament has specifically legislated to allow the publication of identifying details of taxpayers. The first is to be found in the legislation bundle, page 1274, that's tab 4.
I take it we're going to have these in electronic form.
I think they are in the electronic bundle. If they're not, then I apologise. They're in mine.
Well, they're not, the electronic bundle ends at 1241 in mine.
Well, can I apologise? I'm sure we can get you we'll get the court an updated version. I can only apologise for that.
So what's the page number again?
1274, tab 4. This is, the section is headed Publishing Details of Deliberate Tax Defaulters. The Commissioners may publish information about any person if, A, in consequence of an investigation conducted by the Commission, one or more relevant tax penalties found to have been incurred, and then the potential lost revenue exceeds 25,000. And then subsection 4, there are details as to what information may be published. The subsection 5, the person must be afforded reasonable opportunity to make representations before it's published. And then there are limitations on how long the information can be published for. Now, similar provisions are found in the next tab in relation to tax agents who've incurred penalties. But what's striking about this, we say, is that Parliament has thought it necessary to authorise the revenue to publish details of individuals who have been found to be in default, who have incurred substantial penalties, and then, having so legislated, has put in a number of safeguards in terms of permitting representations, the length of time publication can be for, and so on.
I think that more broadly what you say is that if there is an underlying well-understood principle about taxpayer confidentiality in relation to their personal tax affairs, and if the Sims principle applies, that if Parliament's to erode that, it will only be taken to do so by specific words, you say here are two examples where that has been done by a specific
Yes,
person.
my lord. I'm grateful for that way of putting it. I certainly say that, and I also say that this casts light on how Parliament understood Section 18 to operate. Because if my friend is right, if the Revenue are right about Section 18, this legislation is wholly unnecessary. The Parliament has gone to the trouble of legislating specifically about how to disclose information about defaulting persons, when actually Mr. Hartnett could have just called in some journalists and told them without any statutory authorisation of any kind. My Lord, my Lady, we say that that's a very powerful indication of the way that the position was actually understood. Finally, we say that the Revenue's own understanding of the position is clear and consistent with our submissions. I won't say anything. There's the guidance. I'll come back to the guidance if I may, because under legitimate expectation. But in view of the time, can I just take one very powerful example? It's at page 205. It's in our Statement of Facts and Grounds, and it's a very well-known letter that was sent by beginning at page 204, a very well-known letter sent by the Revenue to the Public Accounts Committee explaining their legal view of the disclosure position, because the court may recollect there were some rather fractious Public Accounts Committee hearings where Mr. Hartnett was quizzed about deals which he may or may not have done with Vodafone and others, and was asked to give details and refused to do so on the basis of taxpayer confidentiality. He was then, the committee was unhappy, and he agreed that he would set out HMRC's legal views in writing. Now, we've quoted from this extensively, but perhaps the most important part of it is at halfway down page 205, which deals specifically with section 18.2a. There's no express power in legislation to make disclosures to Parliament. The question is therefore whether disclosure would fall within the exception in section 18.2a, which permits disclosure for the purposes of HMRC's functions. HMRC recognises it's part of its functions to assist Parliament. On that basis, it's consistently taken the view it's lawful to pass non-identifying information to select committees through this gateway. However, it does not follow from this it's necessarily properly part of HMRC's function to provide disclosure of taxpayer-specific information to a select committee. The question is whether it would be so is far from free of doubt. We emphasise again the potentially criminal context. It's far from free of doubt because, for example, taxpayer-specific information is of a different and much more sensitive character from non-identifying information, engaging different statutory duties. B, our assessment to date has been that if taxpayers believe that their information may be disclosed, it will make it much more difficult for us to collect tax, thus having a positively detrimental effect on the functions identified in section 5. So, first of all, the Revenue here expresses severe doubts whether even to Parliament it can give identifying information, even though it's for part of its functions. It recognises expressly that identifying information is in a different class from other information. And then, relevant to my next submission, but I'll just take it up now because it's convenient, the question is, assuming there's no prohibition, so assuming it is under section 18.2a, is there a discretion to disclose in any event? And then, over the page, he goes on to deal with the sensitive factors that are involved, and sets out a number of considerations: the damaging effect on voluntary compliance by taxpayers, the damaging effect on ministers, the damaging effect on relationships with other government departments, and the damaging effect on our reputation for impartiality in the handling of individual cases. So, put shortly, what Mr. Hartnett is telling the Public Accounts Committee is he can't give any identifying information, first of all, because he's probably got no power to do so, and even if he has power to do so, as a matter of it would be not a proper way of exercising the discretion to disclose. But we say that that's right. And there's no logical distinction between the position he took in relation to Parliament and the position he took in relation to journalists. I suppose it might be said the factors in favour of disclosing to Parliament are stronger than the factors in favour of disclosing to journalists. But I don't have to make that point. All I have to say is that those considerations must plainly apply to the disclosures in this case. So we say that looking at those matters, taking those matters together, despite the apparent wide words of Section 18.2a, when it comes to identifiable taxpayer information, the power is much more circumscribed than it appears. And there is no power in this kind of situation to disclose individual taxpayer information. If I'm wrong about that, then we come on to the question of discretion. And then one needs to look at the purposes for which Mr. Hartnett says he disclosed the information. The primary purpose of the disclosures was to demonstrate to journalists and the public how seriously they took tax avoidance. That can't, we say, be any possible basis for disclosing any information concerning the appellants. That's all the more so because Mr. Hartnett says that his intention was that none of this would come out publicly. So he's not saying to the public, Mr. McKenna is a man who is organising improper tax avoidance schemes. So he's not even achieving some purpose of public information. A secondary purpose of the disclosure appears to be somehow, if he was candid with the journalists, they'd be candid with him, somehow picking up information from the journalists. We say that it's impossible to see how that could be a proper purpose, a proper basis for exercising any discretion he does have. It can't possibly be proper to trade information with journalists. In any event, it's clear on the face of the transcript that Mr. Hartnett, that the journalists were volunteering information to Mr. Hartnett, and he certainly didn't need, he introduced Mr. McKenna into the conversation, and he didn't get anything out of it. It wasn't that you give me Mr. McKenna and I'll give you something else. The conversation didn't work like that. The first instance judge considered that it was easier to justify these disclosures. I've dealt with this point a little already, because they largely related to HMRC's view of the appellants, which he said was materially different from category from private information and much more easily justified. Well, it is a materially different form of information, but it's, in a sense, we say, much more damaging, because here a newspaper is being told what the revenue think of a particular taxpayer. And this wasn't public domain information. As I've said, it was never, the view of the revenue was never previously stated in the public domain. And one can see that from the very simple fact that this was worthy of a front page story in the Times. This was news. This was something which was worth splashing because it was new. And finally, HMRC seek to justify the disclosure by reference to their belief that the information will never come to light. I've already dealt with that, and we say it doesn't help. It's even if there was a cast iron confidentiality agreement in place, information has been provided to a third party, and there's an obvious risk of dissemination. So we say that the decision, even if there's a discretion to disclose this information, for the reasons Mr. Hartnett himself gave to the Public Accounts Committee, and for those additional reasons, the decision to exercise that discretion in favour of disclosure was unlawful. So that was what I was going to say about the first of the three substantive areas, four substantive issues before the court. The second,
I thought that was the second.
It's
It's part of the first, is it?
That was my second point, but the first issue, milady.
Right. Okay.
As you know, there are four issues identified in the statements of facts and issues, and that was the first. The second issue is, if I'm wrong about that, was there a breach of legitimate expectations or an abuse of power? But we say that, first of all, it's plain that a public body must comply with its own policies when exercising its discretionary powers. We've cited a number of well-known authorities in our case, but it's perhaps sufficient to say, for present purposes, to say this. Mr. Justice Sales, as he then was at first instance, accepted that a legitimate expectation arose out of the relevant guidance. That's paragraph 57 of his judgment at page 170 of the bundle. He rejected Mr. Eadie's arguments to the contrary. That wasn't challenged in the Court of Appeal. And it's not my understanding that the Revenue seek to challenge that now. The position is that there is considerable guidance on information disclosure, and it's accepted that there's a legitimate expectation that the Revenue will follow it. That guidance provides, and the crucial part of it is what's called IDG 40430 at page 413, Appendix 3.
Barry, can I have the reference again?
It's page 413, IDG 40420. If you go back to page 408, this forms a sub part of the of guidance IDG 40400, which is sharing information outside of HMRC. Disclosure for HMRC's functions. So there are then various parts to this guidance. And why this is, the court will see why this is the crucial part. It's the guidance on sharing information outside of HMRC, disclosure for HMRC's functions, disclosing customer information. What happened in this case? So the first point to make is the very first paragraph. HMRC may disclose customer information, i.e. information which identifies a customer or allows recipient to deduce information about identity, where such disclosure is necessary for the purposes of HMRC's functions. So there's a necessity condition. They say we'll only disclose where it's necessary. Turning the page to 414, the third paragraph, they also make it clear that proportionality is a particular consideration. The balancing the infringements of individuals' rights to privacy against the necessity of disclosure. Under the next subheading, how to make a lawful disclosure, it will be lawful to disclose customer information provided only the minimum level of information about the customer is disclosed to allow the function to be carried out. And again, repeating, if the disclosure is necessary. And then, under common situations, the next subheading, they look at the question of whether disclosure situations where it can be carried out without making the disclosure would nevertheless bring broader benefits. They say in the next subparagraph, the disclosure of customer information, for the disclosure of customer information, this is not sufficient. There must be a more direct connection to HMRC's functions. Such disclosures cannot be made for purposes of functions, but often another lawful method of disclosure, such as a legal gateway. So what we say comes from that guidance is that disclosure will be made only where it's necessary, proportionate, and directly connected to HMRC's functions. And if one turns to the examples that they have in mind, one sees how narrow they're putting it, how narrowly it's put. So it's just below halfway down on page 413, examples of necessary disclosure. Passing debt details to an official receiver in bankruptcy work, providing the police with details of a forthcoming visit, making inquiries about a customer to a third party, carrying out distraint in a public place. Those are all examples of disclosures directly related to the collection of tax in a particular case. We say that guidance, there's a legitimate expectation that guidance will be followed, that information will be disclosed only where it meets the conditions set out in, meets the guidance set out in 40430. In this case, we say it plainly doesn't. This is not a point that the Court of Appeal dealt with. The judge dealt with it by saying, well, it was a matter of evaluative judgment, and Mr. Hartnett could rationally and lawfully take the view that the disclosure was necessary in compliance with the guidance set out. That's at paragraph 61 of his judgment, page 171. We say, sorry, there's one other general point I ought to make about the guidance. As Mr. Justice Sales notes, the revenue did not take the point below, and as I understand it, don't take the point in this court, that the guidance isn't sufficient to meet the required standards for legitimate expectation, that it's not clear, unambiguous, and devoid of relevant qualification, that they accept that it does meet those requirements. Now, in this case, disclosure of HMRC's views of the appellants was not necessary for the purpose of tax collection. How could it be? We're talking about historic partnerships which are marketed some years earlier. How can it be necessary to say that the revenue think that these are a bad thing? I mean, either they are or they aren't. That's a question ultimately the first-tier tax tribunal will determine at some point, perhaps fairly shortly. But it can't be necessary to tell the Times that that's their view. That there was it was disproportionate to the legitimate aim of encouraging tax collection. It's difficult to see how attacking the reputation or setting out the views, put more neutrally, about a particular individual is proportionate to that aim. And there's no direct connection at all between that disclosure and the tax collection function. The best it can be said, as we understand it, is that if the journalists thought that Mr. Hartnett was being candid with them, they might help him. Well, that in itself doesn't suggest whether that would lead to the collection of more tax is entirely speculative. There's no clear connection of any kind. So we say that this is a straightforward challenge on legality, that there's a breach of legitimate expectation and the disclosure was unlawful. We also put the same point in terms of fairness and abuse of power. It may just be a different way of looking at the same point, but my Lord Tilson has already referred to the well-known Fleet Street Casuals case. In that case, certainly Lord Scarman took the view that there was some division in the House, but that there was a duty of fairness to the general body of taxpayers, that nobody should be singled out as a favourite or sacrificial victim. Here, effectively, Mr. McKenna is being singled out as someone whose affairs can be discussed because it might be helpful generally to the revenue. To counter the press complaints about cosy dealings, you say, well, I've met Mr. McKenna and he's a man who's running scams, and it's don't worry, everything's under control. And it is significant, we say, that the judge in the Court of Appeal played down the significance of this point, but we say it is important that at this stage there'd been no formal decision about these tax partnerships at all. Its own investigation hadn't been concluded.
I wonder if this is perhaps a wider point. I mean, your legitimate expectation, based on the guidance document, is obviously limited to the scope of that document, which is about information identifying or enabling the deduction of the identity of what they call customers. Whereas your abuse of power argument, I'd have thought, is wider than that, because it's not just to do with identity. It's, I'd have thought, to do with making allegations about individuals or companies, whether they're taxpayers or not, which are potentially damaging, with no, of course, no procedural fairness involved, and where it's difficult to identify any power or function of revenue to which the allegation is relevant.
Your Lordship is right. It does go wider, and I although I'm dealing with them under the same heading, this is wider than customer information. It's a basic fairness point that it's not. Your Lordship put it very well. It's not fair to attack a particular individual, to a journalist, in circumstances where you haven't actually told the individual that that's your view. You haven't actually said to him, we think your partnerships are tax avoidance schemes.
Well, I just wonder if unless you can, the functions are statutory. Unless they can point to some statutory function, then it's simply an abuse of power.
Yes, yes. Although what they say is that the functions, taking my Lord Tilson's point, that really the functions are anything they think they are, and they're very, very wide indeed. And so they think they're helping, the revenue is helping itself by doing this briefing, and so it's all right to get the gloves off and say these things about Mr. McKenna.
That's why I suspect that all your different ways of putting the case collapse into the first one.
Mm-hmm. Well, my Lord, they're all aspects of the same thing, if I can put it that way.
I mean, it so happens in this case that we're talking about a taxpayer. But say, for example, there was a firm of accountants who who specialised in tax avoidance advice. The revenue decided to give a press briefing attacking that firm of accountants as irresponsible and causing all sorts of adverse social consequences because of the diminution in revenue consequent on their activities. Then you might ask, well, what's the statutory basis for the revenue doing that? And unless they can point to something, then it's misuse of power.
Yes. Well. But even if they have a statutory basis, even if the statutory powers go as wide as Mr. Eadie says they go, then we say it would be abuse of power to single someone out in that way. But it's not it's not the same as an Article 6 a prejudgment of a criminal offence point, but it's analogous. Here we have the revenue, as it were, giving its view in advance of any proper determination. And even if it had a power to do that, it would be abusive, we say, for it to do it in the way that it did. It's important to note that the way that the respondents have put their case is that Mr. Hartnett is giving his own views as to the nature of Mr. McKenna and his business. So, for example, in the detailed grounds of resistance at paragraph 18 at 222, it said this is Mr. McKenna's own view. Reference is made to his personal view of Mr. McKenna. Now we say that the paragraph 22, paragraph 22 at page 222, what was actually disclosed was Mr. Hartnett's view of the claimant's film schemes. And it's particularly important, we say, that Mr. Hartnett is apparently giving this briefing with a view to discourage people from doing business with the appellants. One gets that from his witness statement, and it's perhaps important just to look at the passage because it's, we say, startling. Page 322, Appendix 2, tab 3. The last few lines of that paragraph. I therefore hope as a result of this briefing, the journalist, this is paragraph 23, page 322, that the result of this briefing, the journalist will be prompted to emphasise to the public investors in such schemes will be asked searching questions by the tax authorities, and it might have the effect of discouraging people from investing in them. Given that the public stance on such schemes, I consider this to be appropriate. So he's seeking to discourage investment by making these statements to journalists. That we say, in the circumstances where there's been not even any closure notices, is an abuse of power.
In other words, the view that he was expressing was based on material considered to be insufficient to take action against Mr. Kenner.
Considered at that time to be insufficient. Later on, 5 months
yes,
later.
yes, but at that time.
Yes. And it was a personal view, and it's not really clear to what extent how well informed he was. There are times when he doesn't really appear to know what's happening. That's understandable, but to express those views to a Times journalist in circumstances where, with the obvious risks, is what we say is unlawful. Can I turn just briefly to the Article 8 and Article 1 of the first protocol points? Article 8 is we say, it's a facet of the same point, although in one sense it's a straightforward route to.
But it must be your case that even if they had issued a decision, a closure notice, what happened would still have been illegitimate.
Yes. On the other hand, if the Revenue had issued a closing notice and then said publicly, we've issued a closure notice, then that may have
Well,
been...
how could that be justified in your case?
Well, as soon as there's first tier tribunal proceedings, it's a public matter, and that's then in the public domain, and then there's the exception to Section 19. Perhaps not before the first tier tribunal proceedings, but once those were commenced, which was very soon afterwards, these matters were then in the public domain.
One of the weird things here is that on the other side's argument, that doesn't make any difference anyway, because Section 18 prohibits them from saying what is in the public domain.
Yes, unless there's a gateway, yes.
Quite.
Well, that's what's troubling me. I mean, they're entitled to add anything to whatever the public is bound to discover, if it is bound to discover anything from the fact of the proceedings. On your case, they can't issue an announcement or a report saying, we have taken the following steps.
Well, my lord, perhaps not. But of course, that's why they were given specific powers under the Finance Acts to name and shame. But without those specific powers, then no, they can't start putting out press releases about their litigation. I think that's right. They're in a particularly sensitive position as holders of all the confidential information that they do hold.
What do the first tier tribunal rules say about this?
I'd have to get instructions on.
Well, yes, but it would be quite interesting if we're going to explore this matter.
I'll certainly do that. Yes.
They don't issue. Do the Inland Revenue issue annual reports of their activities or anything like that?
I'm sure that they do, but whether they deal with the, I'd be very. Well, the short answer is I don't know. But of course, they can do that without identifying individual taxpayers. They don't have to say we've done jolly well this year. We've extracted, 100 million out of this particular individual. They can say, our total collection this year in this field are so much.
But it's coming back to your broad... Say so.
Yeah. No, I was just going to say it comes back to the problem that I raised at the very outset, supposing there's a very limited market in relation to film schemes, and they issue a report saying we have targeted film schemes. They're inevitably pointing the finger at particular people.
Well, if they did that, that's identifying information for the purposes of Section 19. If there was one particular product and there was only one or two people marketing it, then they would be committing a criminal offence unless they got through one of the Section 19 defences.
And the Section 19 defence, if they said that we were doing it in order to make it quite clear to the public so that there was no misleading and people weren't encouraged to do this sort of scheme, which would that fall
No, I don't think that would be sufficient. There's of course a whole series of gateways which we haven't looked at, which are precisely because of the rigour of the prohibition in Section 18, there's Section 20, which deals with public interest disclosures. And then there's so in 12, this is 1253, or for those who don't have it electronically, which may be everyone, it's at tab 1, page 1253 of the legislation bundle. But there's a provision on public interest disclosure, and that permits, under subsection 2, to disclosure for preventing crime, under subsection 3, to public authorities. Sorry, I'm just trying to summarise. Disclosures to a person exercising public functions for the purposes of prevention and detection of crime and in order to comply with an obligation of the United Kingdom under an international agreement.
There's going to be all of those conditions, yes.
And then, yes, all three of them. And then a body responsible for regulation of a profession when it's misconduct relating to revenue and customs, to constables when it's relating to the movement of goods in or out of the United Kingdom, National Criminal Intelligence Service, the matters related to public health, to the Secretary of State, and so on. But these are again limited gateways that they can go through.
Mr. Thomas, coming back more broadly to Article 8, I'm afraid at the moment I'm at a loss to see what Article 8 adds to your first ground. For this reason, we all know that Article 8 extended the protection of the law in some areas of privacy beyond that which was accommodated within the traditional law of confidentiality, and the UK courts have expanded the cause of action for breach of confidentiality to accommodate wider privacy issues. That's the Naomi Campbell case, Douglas and Hello, and so on, all very familiar to you. But the territory with which we are now concerned, taxpayer information confidentiality, is a very well-worn and established general principle. We've got a question of construction, whether Section 18(2) significantly contracts it, but I can't see that Article 8 adds anything to that issue. It's the same thing presented under a different package, isn't it?
Well, what it adds is that there's a clear analytical route it goes a slightly different way, which is the Article 8 right to reputation. So we're not talking about Article 8 as it got into the tort of misuse of private information, or Article 8 as it protects confidentiality or more generally public information. We're talking about Article 8 as it protects a person's reputation, which is a sort of outward-facing version of Article 8, which we say does add something. And can I just try and the way in into this is to look at a case called Mikoljova and Slovakia, which is at page 1073.
Are there circumstances in which you could fail on your first ground and succeed on this one?
Yes.
Right.
And let me just try and make it clear why I say that. If the position is that the power is a wide one, that it's an evaluative judgment and that the court won't interfere with, it's super Wednesday, but not necessity and proportionality. The legitimate expectation doesn't help me. If the position is there's an interference with the Article 8 rights of certainly of the second appellant, a human individual, then there's no doubt that a necessity and proportionality test has to be applied. So the test is a stricter one So if this court were, along with Mr. Justice Sales and the Court of Appeal, to say, well, look, we're not experts in how to brief the press. I mean, this is effectively how the lower courts put it. We're not experts in how to brief the press. Mr. Hartnett made his judgment as to how he was going to brief the press. It's a matter for him. We can't say it was completely bonkers off the Richter scale. Therefore, what he did was lawful. But under Article 8, I'm still entitled to say, well, the court, have to do the necessity and proportionality exercise. It's not a matter for Mr. Hartnett's judgment.
Yes, thank you very much.
Mikoljova, I'm not very good at pronouncing the Slovak, I'm very sorry, was a case involving, as I say, tab 15,073. It was a case where the applicant had allegedly assaulted her husband, and her husband had made a report to the police, which he'd then withdrawn. But the police had recorded that the offence had been committed. And if one gets that from paragraph 9 of the judgment, this is, I would say, I'm not sure that this adds very much, but I'll say it anyway, at the fourth section with Mr. Justice Bratzer presiding, paragraph 9 is what's recorded in it by the police, which is the investigation shows the applicant's actions met the constituent elements of the offence of causing injury to health pursuant to Article 221 of the Criminal Code. She deliberately inflicted an injury on another person. So it's recorded that she's committed a criminal offence. That document is then sent by the husband's insurers asking the wife for a contribution to his medical expenses. So the husband's has been insured for medical expenses. The payment out has been made, and they say to the wife, you assaulted him, you should pay. She complains that this is an interference with her Article 8 rights, because this is damaging to her reputation, and there's no justification for it. The government argued, and this is important for the purposes of the reasoning of the Court of Appeal in this case, the government argued, this is at 52, that she had not specified, she couldn't rely on Article 8 because she hadn't specified any particular consequences of the decision for her private life, and she hadn't even claimed that the allegations were false. So they say, well, effectively, this is all, that you haven't really shown your private life is damaged at all. That argument is rejected by the court. Paragraphs 53 to 55 set out the general position in relation to the Article 8 right to reputation, referring to the court's case law beginning with Chalvey and France and going through Pfeiffer and Austria, and making the point that these have to be allegations which are of a seriously offensive nature. Now, the court concluded that the disclosure of this document by the police to the insurance company was an interference with the Article 8 rights of the applicant. That's paragraph 57. Violent criminal offence coupled with the uncontested disclosure of the impugned decision to a third party. They then considered whether or not assuming that this was in accordance with law, assuming that it was for a legitimate aim, was there a fair balance between the competing public and private rights? And the court concluded that, paragraph 63, that they'd failed to strike a fair balance, and accordingly there'd been a breach of Article 8 of the Convention. Now, the judge in the Court of Appeal said that the judge took the view that there wasn't interference with Article 8 rights at all. The Court of Appeal didn't address the issue, but assuming that there was, held that it was justified under Article 8.2 because it was disclosure to a limited class and intended to be limited to them alone. See paragraph 57 at 144. In this case, we say that the disclosure to a highly influential newspaper that the applicants were selling tax avoidance schemes which are scams is highly offensive and damaging to reputation, and plainly had the potential to affect Mr. McKenna's business, professional activities and relationships. Even if there'd been no onward publication in the newspaper, it would have been...
It had the potential to affect his business relationship.
And his personal relationships.
And his personal...
Because he's being described as a man... He's a man of... You've seen from the statement of facts and grounds, he's a man who how can I put it, is on the face of it a highly respectable member of the establishment, occupies many distinguished public positions. It's saying he's running scams. I mean, scam can only mean dishonesty. It's bound to have an adverse effect, we say, on his on the whole range of his activities.
But the whole range can't be material under Article 8. It's got to be his personal.
Well, it's got to be at least his at least his private life. And we say that that's the position here.
Private life, but Article 8, private life can include business, can't it?
Yes, yes.
Yeah, exactly.
Yes, so it's Sidibras and whatever the case is, I've now forgotten its name, Lithuania. Personal can go very wide. So the position here is that, first of all, even to journalists, it would have been bad. It's been more widely published. The reasons given for the Court of Appeal for rejecting the approach in that case at paragraph 58, 145, are misconceived. First of all, they suggested that there was some adverse effect of disclosure in that case, for example, on the insurability or the premium payable. That's just a mistake. First of all, there was no adverse effect claimed, and it wasn't her insurance, it was his. So that's simply wrong. Secondly, they say, well, there's no evidence of damage to reputation. Well, there was no we don't need evidence of damage to reputation. There was no evidence of damage to reputation in that case. And then they say, well, it was a more serious allegation. We don't accept that. This is an allegation of an act of violence, an allegation of promoting scams which have cost the revenue up to £5 billion. It's difficult to say one is obviously more serious than the other. So we say that in those circumstances, Article 8 is engaged. There's no justification under Article 8.2, because under Article 8.2 one has to apply a strict necessity and proportionality test. And so
this decision means that if you're going to rely on a police report about a motor accident, what you have to subpoena it during the course of proceedings. You can't ask the police to disclose what they've their investigations in advance. I mean, it seems to go quite a long way.
No, because it will obviously these things are obviously fact dependent, and one of the crucial facts in that case and in this case was an imputation of actual guilt. If you simply describe what happened, then you're not going to, you may not engage Article 8 at all.
I thought police reports were intended to lead to conclusions.
I'm conscious of the time and I'm already running over. Can I just say...
You've got a minute left.
I'm most grateful. Can I just say about Article 1 of the first protocol? Our submissions are set out in the case. I'm not going to repeat them, but I make the point I made at the beginning. It's not a freestanding point in this sense that I accept that if everything else that happened was lawful, Article 1 is not engaged. What's important in this case about Article 1 of the first protocol, we say, is that there was a deliberate attempt to damage the business of the claim. We added that when we added this claim when we saw the evidence. There was a deliberate attempt to damage, and that's why it's an interference. It's a direct attempt by the state to expropriate the business of Ingenious. I think I've now come to the end of my time.
Thank you very much, Mr. Tomlinson. Ms. Simon? Well, we will now adjourn and look forward to hearing from Mr. Eady at 2:00.